Right. So, we've started in the questions before talking briefly about the kinds of situations where a formality requirement happens. So where we will focus and where those desk lectures focus is on talking about formalities that arise out of some very ancient legislation called the Statutes of Fraud. And you will see the Statute of Fraud successor or successor legislation for the Statute of Frauds. Those kind of language are used in the textbooks over and over. But again, as I tried to point out earlier, there are lots of different, more modern sources for formality requirements. For example, the Australian consumer law means that if you are selling things door to door, you need to leave written documentation, and that needs to include certain provisions, including the calling off provision. If you want to sell a boat or a car or something that needs to be registered, you need paper or a written contract for that registration to be processed. Certain kinds of dangerous goods and poisons can only be transferred to people who are licensed in some way to receive those goods or poisons or chemicals, and as a consequence there needs to be a paper trail. By paper, it could be electronic paper, by the way, but there still needs to be a document that evidences that. So again, we talk about it a lot in the context of the Statute of Frauds, but the provisions or the principles are the same when we think about it in a broader context. So the consequences of failing to meet the formality requirement can change from state to state. So I'm going to focus on Victoria, in particular in relation to the Goods Act, which is the successor legislation for the Statute of Frauds here. But you do need to ask the question in each place. Now, sometimes a requirement to have paper will affect the ability of that document to be enforced, or for that contract to be enforced. So the classic example is land. Unless you have a transfer of land that is documented, you cannot register that transfer at the Land Titles Office, and a court will not hear a dispute in relation to that contract. So it doesn't mean that you don't have a valid contract, it just means that the contract can't be enforced. Now that'll do your head in for a little while, right? Because we've been talking up until this point about a contract or an enforceable agreement as being different from a social or other agreement because it can be enforced by a court. And now I'm saying, well, there are certain types of agreement, unless we have a piece of paper, you can still have a contract, you'll have all of the formation elements there, but a court won't hear you dispute in relation to it because there is no paper. So we'll keep coming back to that. Hopefully it'll make a little bit more sense to you as you go. So what's the rationale behind the Statute of Frauds in the first place? What's the rationale of a law that says you need to have your contract written down? Any takers?
It was preventative of a very specific historical situation.
It's to prevent a very specific historical situation. It's called the Statute of Fraud, so let's guess that it was trying to prevent fraud. What kind of fraud?
Fraudulent practices which are commonly endeavoured to be upheld by perjury and supporting of perjury.
Okay.
Dodgy witnesses?
Dodgy witnesses, thank you. We can all recognise. So basically, if you've got something in writing, the courts can focus their attention on the writing. They then need to work out what the writing means, is it sufficiently certain, does it have all of the elements, but they are avoiding things coming to court because of a he said, she said type argument. So that clogs up the courts, it takes time. What other reasons might you have? I think it's more likely that people are telling the truth if they had a contract, if you can actually hold contract the noun as opposed to contract the verb in their hands. What other reasons might a government like to see things in writing?
Vulnerable people being taken advantage of.
Stops vulnerable people being taken advantage of. I wish that were true. I think it is a big step forward in the process. And much of the modern statute of fraud type legislation or formalities legislation is about that. The example I just gave a minute ago, door-to-door sales. Okay, if it's against the law to sell something door-to-door unless you leave a contract, and that contract includes a provision that says if you change your mind in the next 7 days, you can get your money back. That's there. It also means, although there are lots of kinds of contracts that need to be in writing. For example, under the Telecommunications Act, your mobile phone contract needs to be in writing.
Yeah.
I dare you to ring your mobile phone provider and ask them, could they send a copy of your contract to you, because you've lost it, because they will have great difficulties finding it, because they change their terms all the time and actually getting a consolidated version together. So, and there'll be people in this room who'll tell me that they read their telephone contract from end to end, and I will not believe you. I don't even read. Well, actually, sometimes I do, largely because I can't think of a problem to assign, and I think, oh, wouldn't it be good to get you guys to analyse my phone contract for me? But it's usually too hard, so I haven't done it yet. So let's just look at what the statute of frauds affected to just get our heads around the kinds of things that the law originally was trying to do. So we had contracts of guarantee. What's a guarantee? I guarantee somebody in this room knows what a guarantee is.
But if you don't pay your mortgage, I'll pay it for you.
Thank you, that would be lovely. So a guarantee is a kind of contract. Who is it between? So let's use that example. So that Elliot is going to guarantee my financial obligations under my mortgage. Who does he make that promise to? The way he phrased it, he made it to me.
The bank. Or the
lender.
Yeah.
So it's a contract between a guarantor and the bank, which would support the obligations of the borrower. So the borrower and the guarantor don't have a contract. The borrower and the bank have a contract. The bank and the guarantor have a contract. Why would you want to put that in writing?
So the bank gets its money.
So the bank gets its money, absolutely. Okay. Sorry?
So you can get him to pay it.
So I can get him to pay it? Well, I don't
What are
want
you
to.
saying about me?
I'm not paid my obligations. I'm already dodgy. So, also, again, deals with certain. It's a pretty serious obligation that somebody's taking on. Also, usually not like the consideration I get if I borrow money from the bank and I'm agreeing to pay it back at an interest rate. The consideration is I get this money now. You give me money now that I can use to spend on buying a yacht to put our university on.
Good choice.
And so I've done that. And then what consideration does the bank get?
Interesting.
Interest, right? Basically, the money's worth more to me right now than I pay a larger amount back, and that larger amount is worth more to the bank. Is pretty much how it goes. So, but what's in it for Elliot to support my huge borrowing for this?
The university doesn't go
University of the Sea. Are you going to be the Vice Chancellor?
Yeah, it's an essential term.
Okay, good to know, because I don't want to do that because I want to work from home. I don't need to go to all of those
I short
speeches.
$10 million a year.
So that's fine. You're guaranteed the loan, right? Though, like I'll borrow whatever the bank will give us. That's fine. So I've borrowed this. So what's in it for Elliot to guarantee the loan? What's in it for a guarantor to guarantee the loan? Lexi, by the way, works in property. She spends every, what, 3 letters a week saying, they're going to ask you for a guarantee, don't give it. Don't give it. Like, she's got all twitchy. Don't give it. But why? In what circumstances do your clients not take your advice and give the personal guarantee?
They're related. Or
They're related.
the director of the company who's getting the loan.
They're direct. Well, I'll make you vice chancellor. That's the equivalent of CEO of our university. But yeah, look, they have some business or shareholder purpose usually of doing so. Or there's a very old friend of mine who's at the bar now. Her name's Emma Swart. If any of you get to read with her, you should take it up. But she coined the phrase STD, sexually transmitted debt. That's basically most of the women who have issues with the bank are guarantors. So either for husbands or sons who have borrowed money. So not always, sometimes the daughters borrow money too. So one of the biggest cases you will deal with that gets cited a lot is a Mario, which is a decision about a son who was borrowing money and effectively tricked his parents, who didn't speak great English, into signing a whole lot of documents that they didn't understand. The bank actually were there when they signed the papers over the kitchen table. It was a few years ago now. And so the question became, well, actually should the bank actually be able to enforce that guarantee, when it was reasonable for them to know that the people who were giving the guarantee probably didn't understand the obligations that they were taking on. Are you now worried about the guarantee?
No, what's the name of that case?
Amadio and the CBA, it is. Amadio, you'll come across it, no doubt. So, contracts of guarantee, it's a pretty serious obligation, and it's usually, again, it's where the consideration might be sufficient, but it's very rarely going to be adequate. But then we'll talk about indemnities in a minute, and they're not on this list. Contracts made in consideration of marriage. I'm just going to fly past that one so that we don't get caught up. Contracts for the sale of an interest in land. Land, big investment, specific area. Really, pretty much, you do know that one of Australia's greatest contributions to the world was the Torrens title system and the way that property is registered. And I think we're going to be beaten though by Lithuania, who've taken up blockchain registries, which is very exciting. But anyway, so again, we have a system. What's another reason, other than just for the certainty and making sure that we know who the owner of the land is? Why would a government be particularly interested in having a piece of paper associated with a transfer and interest in land? Tax.
Stamp duty.
Tax. So stamp duty, we've talked about stamp duty before, literally a stamp on the piece of paper. So when the law says we can't hear your disputes unless you've paid the stamp duty, the duty can be applied. It has something to be affixed to. Contracts not to be performed within the space of 1 year. So our university, we're going to launch in 2019, let's say, 2020. It's got a nice sound to it, don't you think, 2020? And so a lot of the stuff I won't be doing until the second half of next year. The stuff that illusory promises I've made when I won't be showing up for work anyway, that we would need to have in writing in a statute of frauds example. Why?
Because we might forget.
Exactly. I think that's actually it. We might forget. It demonstrates the seriousness of the promise. And also, it's not only that we might forget altogether, which both of us forget, that's fine. Given my senior moments today, that's quite likely. But we could have, we have more certainty around what the terms are if they're written down. And then, next one here, contracts for the sale of goods for a price of 10 quid. Interestingly, under the Tasmanian legislation, and actually unless it's changed, I have not checked, but that's now, it's still there, 20 bucks. Why? Why 10 quid? So in 2015, I haven't added it up since, 10 quid's equivalent value in Aussie dollars was close to 600,000, right? Okay, these are big contracts. if it's an important contract, then we need to write it down because we're less likely to have disputes. Is effectively the rationale. Okay, so statute of frauds initially did achieve the objectives that were set out, in the sense that it reduced the number of instances where people were fronting up and disputing what was actually said, because they couldn't go into court anymore. So they were fighting over the written terms, or they just couldn't be heard. I don't think they kept the data at that stage to know whether it actually meant there was an increase in the number of written contracts or not, but it certainly has influenced the way that common law countries do business. However, we live in a very, very different world now. We're contracting online all the time. The spread of information is quite different. When we enter into contracts, we don't actually know what jurisdiction we're dealing with very often, or very often we don't, is probably a better way to phrase that. And the common law approach, this kind of philosophy of throwing words and disclosure at the problem, has probably had the net result that people don't actually read contracts. And part of the work that's being done with law reform in the contract space is around how do we address this and make sure that vulnerable people have the most important terms brought to their attention or understood. And the unfair contract terms takes us quite a long way in that direction. But it has been used to avoid responsibility. So, yeah, no document. I said I'd transfer it to you. I let you do all of that permaculture on my land, but there was no written document, so bad luck. I can't be held to account. So, where do we find these requirements today? This is the most important thing I'm going to do tonight, because particularly for those of you who haven't seen the video, but even those who have, I think we really need to understand this provision. So this is, for those of you who are listening at home, particularly not in Victoria, this is the Victorian provision. It has been simplified in other states, but for our purposes we are learning the laws of Victoria, and this is what matters. So just take a minute if you can. I want to read through this provision. Sorry, Victor, do you want to say something first?
No, can you please clarify the difference between guarantee and indemnity?
I will clarify the difference between a guarantee and an indemnity shortly. I'd just like to go through this first, because I think that's important too. There are two important things I need to do here, and then we'll ask some questions. So, all right, so bear with me. An action must not be brought to charge a person upon a special promise to answer for the debt, default or miscarriage of another person, or upon a contract for the sale or other disposition of an interest in land, unless the agreement on which the action is brought, or a memorandum or note of the agreement, is in writing, signed by the person to be charged, or by a person lawfully authorised in writing by that person to sign such agreement, memorandum or note. Make sense? Okay, let's unpick it. An action must not be brought to charge. What does that mean?
Can't sue him.
You can't sue a person. So an action, hopefully this won't keep changing by slide for me. I'll just try and see if we can do this here. An action, so a suit, an action in a court to charge a person. So charge here we'll explore on a little further in a moment, but to bring an action against a particular person on a special promise to answer for the debt, default or miscarriage of another person. That is a guarantee. Okay? So an action against a person. We're going to use Elliot as our example because he gave the guarantee earlier on. He made a promise to answer for the debt, default or miscarriage of another person, in this particular case, me. Or, so okay, that's one thing. You can't bring an action against a guarantor. Then, an action must not be brought to charge a person upon a contract for the sale or other disposition of an interest in land. What does that mean? So I repeat it, just use the colour coded different. An action to charge a person, I'm using the or here, upon a contract for the sale or other disposition of an interest in land. Okay, so that's actually kind of easier to read than the first one. So you can't sue someone in relation to a contract for the sale of land or a contract for the disposition of an interest in land. Now, disposition and interest in land has been held over time to mean pretty much anything to do with the land. So, creating an easement on the land, creating a caveat that affects the land, leasing the land, an option that would allow somebody to buy the land at a later date if they exercise the option, a sublease of the land. We're comfortable? You've got that, oh, this is scary, these are like legal words kind of faces on you. All gonna be all right. So we're all in the same place. You can't sue a person who's made a guarantee about the guarantee. You can't sue a person on a contract of land or in relation to some other interest in the land, unless the agreement on which the action is brought. So unless the sale contract, the document or the agreement creating the other interest, or the guarantee. Okay, this gets a little bit, oh, I hate it when I do that. I knew it was going to happen. Just want to change my colour again. Unless the agreement or a memorandum or note of the agreement is in writing. Okay, so either the contract creating the interest in land, the contract creating the selling the land, I should say, or the contract of guarantee needs to be in writing, or a memorandum or note of that contract needs to be in writing. Why am I making that distinction? Well, not just me, the Statute of Frauds and the Victorian government in 1953 or whenever this act came out and before. Why are they distinguishing between the contract being in writing or a memorandum or note of the contract? What fundamental contract point does that go to?
Contract doesn't have to be in writing.
Lexi, you are so good at this. Absolutely. It is not a formation element that it's in writing. So the agreement can be formed without writing. It's basically saying, but unless it's in writing, or there's a memorandum or note
Additional to the
or about that agreement. Now this bit's quite interesting. It needs to be in writing, signed by the person to be charged. So what does that mean?
It has to be signed
It has to be signed
by the person.
So in the example we gave at the beginning, where Elliot is the guarantor and I am the beneficiary of, well, I'm not the beneficiary of the guarantee, I'm the contractor, I'm the borrower, you are the bank, you want to sue Elliot on the guarantee. Sorry. I went to
You're
New
one
York.
of the mortgage defaults, that's
Yeah. You want to sue him. Who has to have signed the guarantee? Do you have to have signed it?
No.
What happens if you haven't signed it and he wants to sue you?
He can't.
He can't, absolutely. It needs to be signed by the person to be charged.
Correct.
Doesn't matter whether the person doing the charging has signed or not. Or it can be signed by a person lawfully authorised in writing by that person to sign the agreement. So let's say, Elliot, welcome Johnny, it's good to see you. It was very good of you to accept Elliot's power of attorney and to be appointed to act on his behalf. I found it much easier to deal with you than with him, and getting that guarantee across the line was awesome, given that you were happy to sign on his behalf. So can I sue, can Lexi, the Bank of Lexi 2.0, sue Elliot on the guarantee that he gave to me that was signed on his behalf by Johnny?
Yes.
Yeah.
As
long
long
as
as
there's
the power of attorney.
As long as he was in fact appointed in writing. So if I had said instead, Tobias, will you step up and be the agent? And Tobias says, absolutely, but I'm not signing anything.
Yeah.
Elliot would need to sign to appoint him. Maybe that would be okay. But if there's nothing signed, then the bank can't sue Elliot. Axel, sorry, I'm sitting down. Sorry.
That power of attorney, can that form like a chain of people having power of attorney over each other, or is it just?
It depends on what the power. It depends on the terms of the power. No, it's a really good question. Also, the laws in relation to powers of attorney themselves have changed dramatically over the last few years. And again, that's in relation to protecting vulnerable people. It's particularly come out of some work that's been done in relation to elder abuse. As my husband, we look after my in-laws, he said, he sort of reading over my shoulder and goes, elder abuse, that's a thing? I'm like, yes it is. He's going, I don't think it would be right to sue my parents for the way they treat me. He read it literally the other way around. He thought elder abuse. Yeah, it's like, anyway. So, too much information. But yeah, I mean, if we're just thinking about technically from a common law part, if I grant you a power of attorney that allows you to do anything that I could rightfully do myself, then you could also appoint other attorneys.
Okay.
But usually powers of attorney for exactly that reason are limited to specific circumstances or specific things. Okay, so this is not the easiest thing to read out loud, but at the end of the day, it's a pretty simple concept to get our heads around. If you want to sue somebody in relation to a guarantee or in relation to anything that has anything to do with land, then you can only do that if the agreement is in writing or there is a memorandum or note of the agreement that is also in writing, and that agreement or that memorandum of note has been signed by the person you want to sue or has been signed by their agent. But if we've got that agent situation, then the agent themselves also has to be appointed in writing. And then it just says at the end, yeah, if you can do it under the Electronic Transactions Act, then that counts. All right, statutory interpretation 101. All right, questions, concerns?
What was it before that? Was it just based entirely, as you said before, off the common law precedent in the legislation?
No, well, because in 1677 there was a piece of legislation.
Yeah. It had to be.
And basically it said that. I think it said it in Latin originally. The words are not terribly different, which is one of the reasons why they are a little bit dense and not immediately easy to read. But then if you think about that, we've also had since 1677 many cases around the question of is this piece of writing sufficient to get us over the statute of frauds hurdle or not? And so changing these words and making them completely different would open up the opportunity to rehear all of those cases and create that law. So that's the tension that's being dealt with there. So I'm loving the judge eyebrows. I can see how you were sitting there thinking about how to do that. Questions? Anything more? Right, it does seem pretty, it starts off seeming messy, then it seems straightforward, but it's really important to understand the reasons for it. Oh, gee, we are running out of time, but that's okay. I don't want to go there. Oh, that's right, I want to talk about contracts of guarantee and indemnity. I haven't forgotten Peter. So a contract of guarantee is a contract where a person promises to pay another person's debt if they fail to do so. So the example that we had earlier is Elliot is guaranteeing my borrowing to the bank. So the promise he is making is to the bank. And what he's doing is he is promising that if I default, so it's linked to what my promise is, that he will step in and fulfill my obligations to the bank. An indemnity, on the other hand, is a promise to keep someone harmless and to keep them away from harm or loss in a particular set of circumstances. So if we had, let's use different people, if Robin here had, I'm going to still use the same bank of Lexi 2.0, Robin has decided that she also wants to borrow some money from the bank, and Sue agrees to indemnify the bank against any loss or damage that they incur as a consequence of that borrowing. So what's indemnifying? Is there another word that you can think of that might sound a little bit more like an indemnification? Or insurance, absolutely. So Sue is basically providing insurance to Lexi that she won't suffer any harm or damage as a consequence of doing business with Robin.
So collateral, pretty much.
It doesn't have to. So before I jump to conclusions, what do you mean by collateral?
Something enough to cover the damage.
Yeah, so providing something to cover the damage. So it might just be in the form of a promise. Sometimes an indemnity will include, and guarantees might be enforced this way as well, putting some money in trust and you can only take it out later. Think about it as your bond. If you rent premises and you have to pay a bond, the bond is basically a fixed indemnity amount. It's a provision that's being held just in case you don't leave the premises in the way that you should. Okay, so these are really similar things, but they're slightly different. So Elliot is promising Lexi that I will keep my obligations. Sue, on the other hand, is promising Lexi that she won't suffer any harm or damage as a consequence of doing business with Robin. So that means that if it turns out that my agreement with Lexi, or the Bank of Lexi 2.0, is not enforceable because it turns out I'm a nutter and I don't have capacity. So it's well known to everybody. This is why Elliot was so happy to guarantee. It's like everybody knows she's a nutter. She has no capacity to enter into a contract. No contract can be enforced against her. As a consequence, I have no obligations to you. And as a consequence, the guarantor also has no obligations because his promise is to do whatever it is that I'm obliged to do. Turns out, Robin is also a nutter. Absolutely no capacity to enter into this contract. So what about Sue's position? Does Sue have to pay? No, she's just saying no. Does she have to pay?
Yes, she has.
Yes, she does, because her promise is different from the one that Elliot made, right? Her promise is that she will hold Lexi safe from harm. So, the primary obligation is unenforceable in a guarantee, then the guarantor is discharged. But if the primary obligation is unenforceable, the secondary obligation remains enforceable, even if the creditor's rights against the primary obliger or not. So my question for you, and I genuinely I do not know the answer, is why does what is clearly a lesser obligation need writing and an indemnity doesn't? Now, indemnity is in the form of insurance contracts. The Insurance Contract Act says if you're going to do insurance business, you need to document it in a particular way. But the reality is people give indemnities all the time. Interestingly, in New South Wales, a guarantee doesn't require writing. And I know in Victoria, I think Victoria, Tasmania and possibly Darwin and Northern Territory do, can't remember exactly, but your textbook goes through quite well, and in the slide pack I've made a matrix with them so you can have a look and think about where it is. You will be examined in relation to the laws of Victoria. Does that answer your question, Victor?
Yeah.
Thank you.